So we're ready for your questions, if you have them. Jay. And turn on, you have to turn on your thing tonight, yep.
Hi. I assume that the case that we're talking about, that were transferred to the U.S. Attorney's Office in New York and they're talking about taking back, have been vetted at the U.S. Attorney's Office, and they went through the evidence and they examined whether or not they can get a conviction on the issues that would not raise constitutional questions. So my hypothetical is there are other cases out there that haven't been, and so the hypothetical question is that somebody confesses to a terrorist act, but they're confessed in a coercive confession, but that confession is corroborated. So we know that they're actually a terrorist, and that's the evidence that's submittable. Do you think that what we should do is we should transfer the cases that we haven't seen yet to the to the Article 3 courts, and these people should be acquitted, or maybe you just keep them in prison without any process at all?
Well, I think there are two parts of your question that I think are not consistent, in the sense that you say that you have a confession obtained by torture that is corroborated and therefore may not need these, and that might be put it in the same position as the 9/11 cases, in which I think the government, and the Gailani case too, because if you look at the Gailani case, which is a great example, because it's going on right now in New York. He was charged in the embassy bombings case in 1998. He was apprehended in 2005, I think, in Pakistan, was held in a black site for three and a half years, was transferred to Gitmo at the end of 2006, I believe, with the other high-value detainees, was transferred to New York. He's in federal custody in New York since at least June of certainly no later than June of 2009, when his case was essentially resuscitated, because the embassy bombings case had essentially been over for a long time for the other defendants who'd been tried and in custody already. But Gailani is a case in which the government has forsworn his statements and is relying on the other evidence that they had previously, for which he was indicted in 1998, long before he was ever in custody. So that's always a choice for the government to make in that regard. So in the sense, and it may be difficult to comprehend this, and I'm being serious about this, and I understand from the point of view of the public, if you're not involved in the criminal justice system on a daily basis and on a comprehensive basis, which is that despite what you read in the newspapers, some people who you absolutely certain are guilty aren't. How many people thought John DeLorean was guilty when they saw that video? I may be dating myself. We're going back now, what, 32 years almost? It's 1978, I guess. But really, how many people really doubted that John DeLorean was guilty? He wasn't. He was acquitted by a jury, unanimous, 12 jurors. Really no doubt in their mind that that particular video that showed him opening a case of cocaine was a complete setup for him. So you have to let juries decide the facts of these cases. And, if Khalid Sheikh Mohammed got acquitted, he had to be not guilty to get acquitted. I mean, come on, really? Anybody charged with 9/11 would have to be not guilty in front of a jury of New Yorkers or Americans anywhere to be acquitted. Now, everybody wants to focus on Khalid Sheikh Mohammed. What about the other four? Who can name all four of them? What do you know about them? Do you think it's going to be fair? They're going to be tried with this guy in a military commission just because they're tried with Khalid Sheikh Mohammed? So I think that each case has elements of it, and we want to get into false confessions even without coercion. But the question of the whole dynamic of false confessions, particularly in the context of coercion, is extreme. And look, the consequences are also extreme. There is someone named Sheikh al-Libi, who was a pivotal part of Colin Powell's presentation to the UN in November of 2002 with respect to the basis for attacking Iraq and the presence of weapons of mass destruction by Saddam Hussein. And Sheikh al-Libi was an al-Qaeda operative who'd been apprehended after 9/11, who said that there was a connection between al-Qaeda and Iraq, and it had to do with weapons of mass destruction and all of that. And a couple of years later, it turned out that while he had been tortured and recanted, and his confession was deemed, even by law enforcement people and intelligence people, to be invalid, to be false. So think about the consequences of that when you go forward.
I was asking a different question, by the way. I was asking a hypothetical. I'm saying, given a fact that the U.S. attorney looks at a case and says there will not be sufficient evidence that under the current laws that will acquit this person, and in fact they knew he was guilty. And this is a hypothetical. It may not be true. I mean, your answer is, how do you know that's really valid? But the question is there any circumstance where the government should, in fact, acquit somebody where it's popularly thought and the government truly believes they're guilty, but the evidence is not sufficient that would pass muster in a court? That's
the rules we play by. I mean, if we're not going to play by those rules, it's anarchy, actually, is what it is.
Go ahead. You're fine.
There we go. One of the things that really concerns me about this, having these two different systems, one of the criteria that they came up with to evaluate which forum the cases would go to is which forum would allow for the best presentation of evidence. There's words to that effect. So it's basically what they were saying is, let's take a look at the evidence and see what bar it will clear. And if it'll clear the high bar, then let's give them, a full-blown trial in federal court and feel good about giving them a full measure of justice. But if the evidence won't clear that bar, then we'll fall back on a military commission. And that's exactly what they've done, or vet the cases and determine how high the evidence will jump. And that's what picks the forum, which I think is just fundamentally wrong. And I think the harder question, I think the prosecution, where we prosecute these cases, is a fairly easy question compared to the larger number of people we have no intention of ever prosecuting and never releasing. And what are their rights? That's, to me, is the more difficult question.
I think to that point, I would say we ought to give it a whirl before we start rewriting the Fourth and Fifth Amendments. I hear this argument that there might be 30 or 40 people who are bad folks who will do damage to the country that we won't be able to convict in either the Uniform Code of Military Justice or military commissions or in Article 3 courts, and what do we do with them? Well, first, I think you got to give it a whirl. I happen to think that with the growth of anti-terrorism laws that have been put in place in the aftermath of 9/11, forget the part of the Patriot Act. There's been so much more in addition to that it is so much easier to convict people for crimes after 2001 that you couldn't go after in before 2001. The material support for terrorism, it can be read so broadly as to barring lawyers' assistance to humanitarian groups. That's a Supreme Court case that's now before the court. But we ought to try it. And I think that if in established rules, which I prefer not the military commissions, I prefer the court martials, the UCMJ and Article 3 courts. Those are my two lanes that I find acceptable. If you can't prove a person is guilty, then they walk. That's what happens in America. Guilty people walk when they're not convicted. And if they are radicalized now after being in Guantanamo, does not mean that they were radical extremists when they got there, because that experience will radicalize most anyone. And so you're going to hold them guilty for a crime that the government committed on them by breaking the rule of law and having a different ideology on the way in than they had on the way out. And I think that would just be a debacle for our society.